Good afternoon, everybody, and welcome to our last DMH Stallard employment webinar of 2020. I think it's fairly mild for me to say that it's been a very turbulent year for everybody, particularly those of you involved in HR that are dealing with and will continue to deal with some really difficult issues throughout 2021. We will, I think, be quite glad to say goodbye to 2020, hoping that 2021 brings us some positivity, but obviously we're here to support you through continuing turbulent times. And one of the things that we want to do today is to take you through a review of what has happened in 2020 with regards to some of the cases and also some of the legislation that you might actually have missed. I think we've been so focused on dealing with all things furlough that it's quite easy to stop looking at some of the cases and the legislation that has both happened. But we'll also be looking at what's coming up in 2021 as well, both in terms of cases to be decided in the courts and also legislation that's on the horizon. So with me this afternoon, we have Simon Bellum, who will be looking at some of the cases, some of the legislation rather in 2020. Adam Williams, who will be looking forward to 2021 and the legislation that is expected to come onto the statute books then. Stephen Ten Hove will be looking at some of the predictions that he made in 2020 as to how the cases would actually pan out. So we'll see from Stephen what he got right. And then finally, we're going to have Will Walsh, presenting our employment Christmas quiz for you. So please do stay on to the end. We have some prizes for you. So we'll explain what those are, but you do need to still be with us at the end to have the chance to participate in that quiz and obviously gain some prizes. We won't have the usual Q&A today because we've got a fairly packed programme of content, but obviously if you do have any questions, then please do contact your usual DMH employment contacts. And we will get back to you as soon as possible and hopefully can help you with your query. But I'm going to move on now to Simon, and he's going to take you through some of the legislation that took place in 2020. So thank you, Simon.
Thanks, Rebecca. Good afternoon, everybody. Yeah, stick with us to the end because the quiz is worth waiting for, and the webinar just gets better as it progresses. So in terms of legislation in 2020, I had a choice of two. Where do I start? Either Brexit or COVID, and I decided to start with Brexit. So at the beginning of this year, we had the implementation of the October 2019 withdrawal agreement into UK law. So the position for this year has been that European law continued to apply during the transition period up to the end of this year. And then from January 2021, next year, what will happen is that there'll be established a body of retained or existing law, which is transported into UK law and becomes UK law. And what's going to be interesting is that the UK appellate courts, the most senior courts, that's the Supreme Court and the Court of Appeal, will have the opportunity when they decide cases to depart from existing European law when it appears right to do so. And that phrase is the same phrase that can be used by those courts at the moment when they are deciding to move away from existing case law and start creating new case law. So you can see that there's the opportunity for the Court of Appeal and the Supreme Court to start departing from European law in terms of how cases are interpreted. So moving away from sort of European case law, as it were. EU law no longer has supremacy, and so Parliament will have the option of creating new legislation departing from European law. Whether or not it does so remains to be seen. Most people anticipate that there won't be radical change, and certainly not in the short term. Moving on to COVID, we all know this. Back in March 2020, the government in very quick order introduced new rules on statutory sick pay, relaxation of holiday carryover rules, and also introduced the furlough scheme. All to cope with the pandemic. It was introduced very, very quickly. Initially, there was a lot of guidance, then it was firmed up in Treasury directions, and over the last 6 to 9 months, we've got a little bit more clarity about what some of the rules are. Moving on, each April we have the normal revision to the statutory rates, and the main ones are the national minimum wage rates. So I've set out there the new rates that have applied since the 1st of April 2020. And then in terms of employment rights and claims for unfair dismissal or redundancy, those rates were changed as well. So the maximum compensatory award that can be made by a tribunal for an ordinary unfair dismissal claim is the lower of a year's salary, or £88,519. And in terms of redundancy pay and the calculation of that, the maximum figure for a week's pay that can be taken into account under the statutory scheme is £538. Then a couple of changes in relation to agency workers. Swedish derogation, well, what was that? Basically, agency workers after 12 weeks have the right to the same level of pay as if they were directly employed by the end user. Now, it was possible until April for the temporary workers agency to avoid complying with that if it provided with the agency worker with a contract of employment which was permanent and met minimum requirements, and critically, which provided that the agency worker between assignments with an end user would continue to receive pay. If those provisions were in place, the temporary workers agency could avoid the requirement to pay the agency worker at the same rate as a directly employed worker, and that's been abolished. So essentially it's a simplification. The other change to agency worker arrangements relates to the provision of a key information document. So if we could just move to the next slide. Thanks. So this is, I think, more important and valuable because it gives much greater clarity to an agency worker about the way they're going to be dealt with under an assignment. So a temporary work agency must provide their agency workers with a key information document setting out the things which are on the screen. And those relate either to the status of the agency worker. Sometimes the agency worker will be an employee of the temporary work agency. Sometimes they'll be a worker. Sometimes they might even be self-employed. So it should give clarification of the status of the agency worker. And also it sets out some detail in terms of what they can expect by way of entitlement, who's going to pay them, at what rate, and non-monetary benefits, etc. So quite a helpful piece of information that clarifies the arrangement in relation to agency workers. Moving on, there was a slight change to the law in relation to Section 1 statements. So Section 1 is Section 1 of the Employment Rights Act. It's been around for a long time. Any employer must provide its employees with a statement of the main terms of their employment. And there were some small tweaks to the information that needs to be provided, but more importantly, the right has been extended to workers as well as employees. So we've always had to provide this statement to employees, but now if you engage workers, you have to provide this statement to them as well. So it should provide some much needed clarity. And then the final area that I'll look at is in relation to holiday pay. So there were some changes to the calculation of holiday pay where the employee has variable pay or variable hours. So if you're working out how much holiday pay to pay somebody who has variable hours, historically we've always had to use an average of their pay, and we still have to use an average. But until April, the average was to be calculated over a 12-week reference period, i.e. the 12 weeks before they took their holiday, to work out what was their average pay during that period, and that would then be their holiday pay. The difficulty arose if there were significant seasonal variations in terms of the amount of time that an individual spent working. So, for example, if they were very busy during the summer, so that their average pay during the summer was very high, it would mean that if they took holiday in the autumn, early autumn, then the holiday pay would be high. But conversely, if they took their holiday at a time of the year where they hadn't been working very much in the previous 12 weeks, then their holiday pay would be low. Now, to smooth out those fluctuations, the reference period for the calculation has been increased to 52 weeks. So it smooths out those seasonal variations. And if you've got an employee who hasn't yet worked for 52 weeks, you simply use the number of weeks that they have worked to calculate the average. And then lastly, there's been a change in terms of how far you can search back to build up that 52-week period. So if we move to the next slide, what's always been the case is that when you've been calculating that average over a 12-week period, you only take into account weeks where the employee has actually worked and been paid. So if they work every other week, then it would mean you'd have to stretch back over a 24-week period to find 12 weeks worth of work when they have been paid to establish your average. Well, now, as I say, we're dealing with a 52-week reference period. What the legislation says is that you only need search back for 2 years to try to build up that complete 52-week package of weeks where an individual has actually done some work and has been paid. Okay, so nothing massively dramatic over the course of the last year. I'm going to hand over now to Rebecca, who's going to look at some of the cases that we've seen in 2020. Thanks.
Thanks very much, Simon. I should also say that we will have the slides on the website after the webinar as well. So if you look in a couple of days, we will have uploaded those, and you will have those for a reference point going forwards. But in respect of the cases that have been decided during 2020, I'm going to go through a few of them. There perhaps haven't been as many as there normally would have been. The courts have still been sitting. The courts have still had to make judgments, but I think that they have probably been a little bit slower than they normally would have been. But we've still got some important cases that you need to be aware of. And I'm going to talk through a number of those, starting with a couple of cases that you may be familiar with regarding the principle of vicarious liability in employment. Now, Stephen actually predicted these, so I'm not going to steal his prediction thunders for later on, and he'll go into these in a little bit more detail. But the Barclays Bank case was a fairly unsavoury case whereby Barclays Bank engaged a self-employed doctor to carry out medical examinations on its prospective employees and also some of its current employees. Now, the self-employed doctor was found to have committed various assaults on staff over a number of years, and a class action was brought against the bank directly. Now, the principle of vicarious liability is that the employer will usually be liable for the actions of an employee and sometimes a worker. But the Barclays Bank case at the Court of Appeal went some way further than this and looked at whether the bank should be liable for the acts of somebody who was self-employed. And then this has now gone up to the Supreme Court and had a final determination. I think employers will be very pleased to know that if they're engaging people and they are genuinely self-employed, then being in business on their own account and being genuinely self-employed will mean that the employer who engages them will not be liable for any of their actions, or should I say the organisation that engages them will not be liable for the actions of those self-employed individuals. So the Barclays Bank case, fortunately for Barclays, made clear that there was no liability. Obviously not quite the picture that the various claimants wanted, because they were left without a remedy. And then we also had the Morrison's supermarket case, and this is the Morrison's supermarket case where a rogue employee who had a grudge against the supermarket decided that he was going to disclose the payroll data of the vast majority of the supermarket's employees. And again, claims were brought as a class action on behalf of various employees in respect of potential losses and damages that they suffered as a result of those unauthorised breaches of the Data Protection Act. Again, in this case, the Supreme Court agreed that the vicarious liability doctrine should not go as far as saying that when somebody does an act which is not closely connected with the acts that he's employed to do and were not authorised to do, then the employer should not be vicariously liable for those acts. Effectively, Mr. Skelton, the rogue employee, was pursuing a personal vendetta, and it wasn't fair for the supermarket to be responsible on the vicarious liability principle for Mr. Skelton's wrongful disclosure. So hopefully turning the tide a little bit on some of the vicarious liability decisions that we've seen over the last few years. Moving on now to age discrimination. So the case of Heskett and Secretary of State for Justice was heard only last month, or sorry, the decision only came out last month. And this involved a policy that had been put forward by the public sector authority of slowing down pay progression. Now, many of you may remember that in 2020 there was a public sector pay freeze, and a lot of public sector organisations had to get their house in order, balance their books, and budget accordingly to ensure that that public sector pay freeze and budget cuts were aligned to what they were paying staff. So in this case, the Secretary of State for Justice put in place a slowing of what was normally a fairly generous pay progression. So you would get paid on the basis of your years of experience and employment with the employer. The policy, the pay progression policy, when it was slowed down, disadvantaged younger employees more than it disadvantaged older employees. So Mr. Heskett brought a claim for age discrimination on the basis of indirect age discrimination. Now, it's been good law for some time that costs alone cannot be used to justify discrimination. So you can't say I'm discriminating because I need to save costs. However, there are some very subtle and nuanced arguments that are called a costs plus argument, where you can take cost into consideration as long as there are other factors that have also been used in respect of the justification for a potentially indirect discriminatory policy. And those other factors in this case, and in fact in a number of cases over the last few years, have been the need to keep to a budget, and in this case to reduce staffing costs to live within its means. Now, I think many of us would probably look at that and say, well, isn't that just to save costs? What this case does, I think, is to give some hope to the fact that when you do need to save costs, you can think quite creatively as to whether there are other factors that you need to use as well. And if it is the case that it's legitimate to impose a budget to break even, then that may be one of the other factors that you can potentially use in your age discrimination justification argument. Okay, so turning next to another discrimination case, the case of Ishola versus Transport for London. Quite an unusual case here, but quite an important decision regarding whether a one-off act by the employer is going to be enough to establish a PCP for the purposes of indirect discrimination, and in this particular case, to establish a PCP for reasonable adjustments in disability discrimination. The courts here said that where you have a one-off act, but that one-off act is highly unlikely to happen again with the same decision in the future, a one-off act will not be enough to establish a PCP. If you think about the sort of common sense meaning of provision, criterion, or practice, that does suggest some degree of reoccurrence, and therefore a one-off act where there won't be a reoccurrence and there isn't a practice that's been evidenced will not create a PCP. So in this case, Mr. Ishola had raised a grievance. He had then taken sick leave and he was dismissed before his grievance was actually resolved. This was over quite a lengthy period of time. It wasn't a rapid and rash decision by the employer. But the court said that the failure to resolve the grievance on the part of the employer didn't amount to a PCP of requiring Mr. Ishola to return to work without a proper investigation into that grievance. So I think, again, this is a case that gives the employer some comfort that they can bat away some of the claims that we're starting to see with employees who are saying a one-off act can in fact be indirect discrimination, and that a PCP has been established. So Ishola is a really useful case to use where an employee is coming up with probably their own quite creative arguments. Okay, the next case, another discrimination case, and the case of Ali and Capita and the linked case of Hextall and Chief Constable of Leicestershire. One of these cases, again, Stephen's going to look at because he had already done a prediction on this. But this case, or these two cases, concerned situations where employers were subject to tribunal proceedings because they paid enhanced maternity pay, but were not paying enhanced shared parental leave pay. And until the Ali and the Hextall cases were decided back in May of this year, quite a lot of employers were of the view that they were either going to have to enhance their shared parental leave pay, or they were going to have to remove the enhanced maternity pay. Now, fortunately, Ali and Hextall, because it decided that there had been no direct discrimination and no indirect discrimination by not paying enhanced shared parental leave, that has left employers in a position where they can keep the status quo. So they only pay enhanced maternity pay and they don't pay enhanced shared parental leave pay. then that is fine. They're not going to be at risk of a discrimination claim. So moving on to a couple of unfair dismissal cases, which are quite interesting. Both cases I'm going to refer to are both at the Employment Appeal Tribunal level. So that is the lower levels, but it's still binding authority. And the case of Gallagher and Abellio is quite interesting because the courts or the tribunals unusually said that a dismissal without any procedure could still be fair. So in this particular case, there'd been a relationship breakdown, so a quite common scenario between manager and his direct report. The direct report had been told at the annual appraisal that she was going to be exited due to lack of trust and confidence. And it wasn't a one-off. This was something that had been referenced on a number of occasions. And it was also considered that if a further process had been followed, all it would have done would have exacerbated matters. And the claimant had already said as well that they had no interest whatsoever in terms of seeking to repair the relationship. So no procedures were followed at all, save that the claimant was told at an appraisal that she was going. I think many of us would have expected the tribunal, the Employment Appeal Tribunal, to say that that was procedurally unfair. However, they didn't. I think they were quite brave. And they said that it was still a fair dismissal for some other substantial reason, even though no procedure had been followed. A big word of caution, if any of you have looked at this case and thought that you can dispense with procedures, our advice would be it would be extreme circumstances that allow you to dispense with procedures. And this is really a rare example of where procedures could be dispensed with and a court finding could still be that the dismissal was fair. Okay, moving on to the case of Evans and London Borough of Brent. I think this is quite a worrying case actually for employers. I think most of the cases I've spoken about today have probably been in the employer's favour. This one I'm not particularly keen on. So what we had here was a situation where the employee had been involved in some financial mismanagement, and financial mismanagement to the extent that he was ordered to pay back a significant amount of money to the employer. Now, that order for the repayment of money had been made in the High Court, but Mr. Evans then decided that he was going to issue tribunal proceedings, even though there was no prospect of a financial award. He wanted to issue tribunal proceedings because he was probably going to get home on procedural grounds. Again, as discussed in the Gallagher case before, procedural grounds can amount to a finding of unfair dismissal. But even in this case where Mr. Evans was absolutely going to end up with nothing from a financial perspective because of contributory fault, because of what we call the Polkey rules, the courts said it was still open for him to continue with his tribunal claim. It wasn't an abuse of the tribunal process to continue. He was entitled to a finding of unfair dismissal. And as I say on the slide, it's quite worrying for those claimants who, you know, are not going to receive anything from a tribunal award financially, but they simply want their day in court. And that may be, you know, a court hearing that's, you know, 2, 3, 4, 5 day court hearing. It's going to incur you in a lot of cost, in a lot of time, a lot of aggravation, publicity. And I think that employees may well use this to try and extract a settlement from employers. Okay, the final case I want to talk about is a TUPE case. I think TUPE's been quite quiet for a couple of years, but this case discussed whether changes that had occurred by reason of a TUPE transfer should be voided. Now, I think most of us are aware that in the vast majority of situations, any contractual changes that take place by reason of a 2P transfer, there's a prohibition on that where the changes are detrimental to the employee. Now, lots of employers do tend to make changes in agreement with the employee, which are beneficial to the employee. And the BEIS guidance says that an employer may vary terms when changes are entirely positive from the employee's perspective. That is guidance only, it's not the legislation. So the Ferguson case looked closely at the 2P regulations and the actual legislation and determined that whether a change is beneficial or whether it's detrimental, there is still a prohibition. In this particular case, we had 4 senior employees, they were directors, I believe, 4 transferring directors who didn't really like what was happening in respect to the transfer of their business. Before the transfer, they decided to change their employment contracts very beneficially, and they put in place enhanced pay, they put in place attractive bonus arrangements. That had a significant disadvantage to the transferee in terms of the amount that they then had to pay to those 4 transferring directors. And they brought a case to say, well, actually, although the contracts had been changed and although the contract changes were beneficial, the regulations did have a general prohibition on any contractual changes. So I think that's a useful case to consider if you're reviewing changes and you're perhaps a little bit suspicious about changes that have occurred pre-transfer to employees' contracts that you may then be welcoming into your organisation. So that's just to run through, I think 7 or 8 of the cases from this year. I'm going to hand over to Adam, and he's going to take you through legislation for 2021 that's coming up. And also, as the eagle-eyed of you will have seen, some hot off the press this afternoon legislation. Thank you.
Yeah, good afternoon, everybody. There's quite a lot to get through actually in my session today, not least because of the impact of the COVID pandemic, and that effectively resulted in a lot of the anticipated employment law changes coming in that were due to come in this year being delayed or postponed. You saw from Simon's piece that there were still plenty of changes that did make their way through, but there's several that have been coming through the process and on stream that have been delayed into 2021 and beyond. So with our hope that the beginning of 2021 will see at least the beginning of the end of the pandemic, on that basis, it's likely we might see some legislative developments finally start to come through and progress further. So want to take you through, there's a few different issues to cover, starting with an important one which I've squeezed into this session, although technically not legislation coming on to the statute books in 2021. It's already recently been put in place in terms of the immigration legislation, but sufficiently important in terms of what happens next year for me to want to include it anyway. And so starting with immigration, from the 31st of December 2020, so New Year's Eve, 11 p.m. UK time, we've got the end of the Brexit transition period, assuming we don't have an extension to that transition period, which seems increasingly and very unlikely. And what that means is that from that point, there'll be no automatic right for EU or EEA nationals to come to the UK to live and work, excluding Irish nationals who still benefit from the Government Act and Common Travel Area arrangements. But all other non-British EU or EEA nationals will no longer have that automatic right to come to the UK to live and work. And it means that the vast majority are likely to require a job offer from a UK employer who will need to have applied to the Home Office and be approved or licensed as a sponsor to sponsor the most common category of visa being as skilled workers, a skilled worker visa. And that's going to involve employers making an online application process, sending in some original documents to prove they're a genuine employer in the UK and have appropriate systems in place to manage their compliance duties. And so anybody who is, particularly those who are UK employers, thinking that they will need to bring EU or EEA nationals into the UK to work from the 1st of January are probably already looking at this, or if not, it's very important that they do in terms of planning. So there's important changes coming in from New Year's Eve in that regard. We've also got, alongside the ending of free movement and the new points-based system, all the changes that play out from Brexit more generally in relation to the EU settlement scheme. And that is for, in very simple terms, EU or EEA nationals who are already living in the UK prior to that 11 PM on New Year's Eve. And that's going to create some changes for employers as well, because by the 30th of June 2021, there's a deadline for applying. If you're an individual in the UK or have been living in the UK, you can technically apply from abroad if you've satisfied the living in the UK requirement, to apply by 30th of June for settled status or pre-settled status. And there's going to be a change in the right to work check arrangements, which there's too much detail to go into in full form today, but essentially means that until the 30th of June, the guidance from the Home Office is you should do right to work checks of EU or EEA nationals in the same way that you do now. But from the 1st of July onwards, there's going to be a requirement to do right to work checks to establish the leave to enter and remain of EEA or EU nationals, because by that point they will have been required to get EU settled status. And that's going to involve changes and shifts towards having an online right to work check system and other adjustments to your processes that you'll need to look at going forward to anticipate that change coming at the end of June as well. So lots happening on the immigration front, and obviously potentially things that employers need to be looking at and preparing for now in terms of sponsoring workers or ensuring that they are ready to do so when they need to. Moving forward, quick touch on the COVID position, and yes, as Rebecca mentioned, hot off the press today, making my slides out of date in one fell swoop, we've had an announcement that the CJRS, the furlough scheme as it's more commonly known, will not end in March 2021. It's actually going to be extended through April as well. So that's been announced today. I think alongside that, there's also been an announcement of some extensions to the business loan arrangements, the period to claim business emergency loans as well, which I saw before coming onto the session today, which may be relevant to some of you. There's a question mark here, though, in relation to the JSS, the scheme that was supposed to come in November, and which didn't, of course, because it was replaced effectively by the extension of the furlough scheme, and whether or not that will come in 2021. Obviously, I was thinking we'd be talking about possibly March. Now looks like it might be April, but it's something to watch out for because it's not entirely clear when that might be reintroduced, if at all. We've also got some statutory pay rates changes coming in 2021. Forgive the typo there, I've just spotted that should say April 2021, of course, given I'm looking forward, not back. And we think these changes in respect of the first bullet point you can see there would most likely come on the 4th of April, which is the Sunday of the week when it's commonly introduced each year. And for the second bullet point, the 6th of April. So we've got statutory maternity pay, paternity pay, shared parental pay and adoption pay expected to rise to £151.97 a week, and statutory sick pay expected to increase to £96.35. You can see there on the 6th of April. So there's some increases there to bear in mind as well. We've also had, and I don't know how many people have been aware of this going on in the background, it's not that well publicised and fairly obscure bit of consultation. We've had a response to a consultation on the Gender Recognition Act 2004, which was published on the 22nd of September by the Equality Office, and sets out the government's response to a consultation around the requirements for certain services and eligibility for certain services to have a gender recognition certificate, known as a GRC, and whether that's a balanced and fair set of requirements, and also whether the process of obtaining one is fair as well. And in that regard, the report, if we, very simple terms, says that the legislation and requirements seem broadly to be balanced, but the process should be improved. The process and experience that transgender people have when they're applying for the GRC should be placed online, and should be a fee reduced from what's currently, I understand, £140 to a nominal amount. Now, that's there's obviously, in terms of employment, there's an indirect relevance there to and questions put around the impact of this on the Equality Act, which essentially the report says are limited, given that there isn't a proposal to change the underlying law and requirements on this. But one thing that did come out of interest was a suggestion that clarity needed to be given in relation to who's protected under the Equality Act, in the sense that we recently had a tribunal case where being gender fluid or non-binary was found to fall within the protected characteristic of gender reassignment in Section 7 of the Act, and that this report, feeding into that and drawing out the different circumstances that apply on gender recognition, indicating that maybe some legislative treatments needed to bring greater clarity into the Equality Act around these sorts of issues. So that's something to watch this space on. We've got gender pay gap reporting that was effectively deferred out for a year as a result of COVID. So the reports are delayed from April 2020, and it's the third round of gender pay gap reports to be published on the 4th or by the 4th of April 2021, if on the snapshot date for that report they had more than 250 employees on the payroll. And there's a question there in my mind about how many people will be required to report, if not in 2021, but certainly looking ahead to 2022, given our unemployment rate is going up, and that calls into question how many employers have 250 employees or more on their payroll at the relevant April snapshot dates. Probably the impact of the pandemic hadn't filtered through enough to make a big difference for a snapshot in April 2020. But what about April 2021 in respect of who will have to report in April 2022? So that's gender pay gap reporting. I'm not sure many of you will be that pleased with the news as employers that, if you didn't know already, the off-payroll rules for the private sector, otherwise known generally as IR35, were delayed, similar to gender pay gap reporting, delayed from April 2020, but are currently due to kick in on the 6th of April 2021. Clearly, there is some prospect that it might be further delayed, but it'd be unwise to rely on that possibility if this is relevant to employers watching. And so that means that there's a need to think about your assessments. Well, firstly, are you in scope? So do you have over 50 employees, turnover in excess of 10.2 million, or 5.1 million on your balance sheet? If you've got two or more of those three ingredients, then you'll be in scope. And this results in a big shift if it applies to you, because it takes the responsibility for assessing whether someone should be treated as employed for tax purposes from the provider of the services, and makes it the intermediary's responsibility to assess, which means you might have some assessments to do in relation to any arrangements where you've got a service provider providing services to you through what we might call a professional services company or a company vehicle, and that onus is shifting to the end user client to make the status determination, and then accounting for tax on that liability, if it applies, will shift to the party who pays for the individual services, known as the fee payer. So for planning purposes, it may be that if you're in scope, you need to make assessments, maybe quite a few assessments in good time for that. So one to put on the to-do list. Next one is a Commission report on changes to the ET hearing structures. Now, of course, there's been a lot of changes to ET hearing structures already this year as a result of the pandemic. Big shift of moving on to remote hearings with cloud video platform, and practice direction guidance on changes to how we'll prepare for tribunal hearings. So this Commission report in some ways has been superseded by that. In other ways, there are elements of it that haven't yet been addressed, but equally haven't gone away. And it was published in April, just after the pandemic really hit, and has 23 recommendations. I think interesting ones are that the suggestion of an increase to the time limits for most, if not all, tribunal claims to 6 months. Obviously, it's currently 3 months, which could have an impact on the number of claims that are able to be pursued and not stopped on the basis of being out of time. And also, another one I wanted to mention was the proposal to potentially increase the limit on the value of damages for contract claims in the tribunal under what's called the extension of jurisdiction legislation to £100,000 from £25,000. So again, if that is introduced, and we don't know whether that will quite get onto the statute books in 2021 or later, could make a significant difference to tribunal claims and the number of contract claims going through the tribunal system, where there's obviously a lower cost risk for claimants, and if this change is made, potentially higher value of award to be made for breach of contract if they succeed. So some interesting points in that Commission report, and we'll need to see in 2021 how and when they flow through. We've also got the employment bill, which again has been on sort of delay as a result of COVID. Was announced in December 2019 Queen's Speech, and obviously it hasn't appeared in 2021. It's expected that the bill will be published in 2020, sorry, it's expected it will be published in 2021. Some of the headlines for that in the bill proposals for introduction are the new single labour market enforcement body, so further potential and potentially fundamental changes to the tribunal system there, focusing mainly on allowing vulnerable people access to a forum to enforce their employment rights, tips and service charge payments to go to workers, and there to be a code of practice about how that happens around what's historically been called sort of trunk masters, and ensuring that workers get the benefit of tips and service charges. An interesting one is the proposal that there'll be a right to request a more stable and predictable contract. For example, if you're on a 0 hours contract after you've had 26 weeks service, to try and deal with some of those concerns and media attention that's been given about the exploitation of 0 hours contract holders and that they don't have job security, etc. Also extending redundancy protection to cover pregnant employees from the date that they notify the employer of their pregnancy and for a period of 6 months after the end of their pregnancy. That's an expansion on the current protected period that applies just during the maternity leave, during which time there are things like the Regulation 10 right to receive an offer of suitable alternative employment if one is available, where it's identified it's not reasonably practical for the individual to return to their old role. And you can see why the extended periods is being suggested to be brought forward and extended after, because that looks to reduce the scope for employers simply waiting, either acting early or waiting till the other end of the protected period before taking action, so that they get around the extra protection in that way. For example, a few months after the individual returns from maternity leave, rather than while they're on maternity leave, in respect of things like redundancies or replacements. There's also neonatal care and employed carers proposals for extended leave in that regard. I think this is unlikely to come in and start in 2021, but we might find that the law is confirmed and written up and made clear with a future date for introduction. But it'll effectively involve parents having a right to take an additional week's leave for every week that their baby is in neonatal care, up to a maximum of 12 weeks, effectively added on to the end of what would have been their maternity, ordinary maternity or adoption period. It'll effectively still, though, only result in pay if you've got 26 weeks service at that relevant eligibility point, the trigger point. And if you do have that and you've been receiving, for example, maternity pay, you would receive statutory pay for the additional weeks. And a proposed right for a week's unpaid leave for employed carers as well. And that's potentially 1 week's unpaid leave per year. So yeah, not likely to actually come into force in 2021, but we may see the legislation coming through. Moving to the next slide. We've had BEIS, or some people call it BEIS, government consultation launched on reform of post-termination restrictions, which is going to close in February 2021. And this is obviously a long-standing issue for employers in terms of the uncertainty that you have around the enforceability of things like post-termination restrictions on competition. So the proposals, including there, the interesting ones are possibly to mandate that employers must continue to pay their former employees for a period of a non-compete. That's not unusual in parts of continental Europe. That is already the case. Obviously in the UK, though, we don't currently have that rule, and instead the employer doesn't have to pay the individual, but will have to explain and persuade a court that the restriction is no more than is necessary and not an unenforceable restraint of trade. The next option, which is even more profound, would be to introduce statute making non-competes void and therefore automatically unenforceable. And you can see if that happens that lawyers may all across the country get very excited about how to find ways of creating a non-compete that doesn't look like a non-compete to circumvent that rule. So that closes in February, and it'll be some time thereafter, probably at least a couple of months thereafter, before we see any meaningful responses coming out as to proposed reforms, but something to watch. And finally, because it takes us to a year from now, when hopefully we will be in a very different place to where we are now, the government's Kickstart scheme that was launched a few weeks back will be closing to new hires in December 2021. It's the end of the period in which you could get new hires under the scheme, and that's a scheme that essentially provides funding to employers to create job placements for 16 to 24-year-olds on universal credit. I don't know how many employers have actually got to grips with that scheme yet and its suitability for them, given all the other things that you've had to be grappling with this year. But yeah, just a marker that by this time next year, we'll be running out of time to put new hires onto the Kickstart scheme. I think that's it for me. I'll hand back to Rebecca.
Thank you very much, Adam. There's a lot going on in 2021. So I think with I'm not quite sure whether it's depressing that furlough has been extended to the end of April. It's a case of what do they know that we don't know. But there's obviously going to be a lot beyond furlough and COVID that we've got to grapple with in 2021. I'm going to move quickly though to Stephen Tenhove now. And Stephen always does his homework for us, so we don't have to do it. And Stephen's going to take you through some of the predictions he made for 2020 and more excitingly, the predictions he's making for 2021 and the cases that are about to be determined by the senior courts. So Stephen, I'll pass over to you.
Thank you very much, Rebecca. I suppose it's a useful thing to know whether your lawyers can actually predict correctly the outcome of various cases in which you're involved. And taking this up as a theme at the end of every year in our presentations in London, I always do a small spot where I look at the leading cases for the year to come and then give my view about who is going to win them and who is going to lose them. And I'm generally tend to be a little bit more successful than unsuccessful in predicting the cases. And it also gives an interesting format, I hope, into which to discuss the more important cases of the year ahead, and to look back at the cases which have occurred in the past year. The first case I'd like to have a look at from 2020 is Lee and Asher's Baking Company, which is the famous Support Gay Marriage bakery case, which ultimately the Supreme Court found in favour of the Asher's Baking Company. Now, interestingly, Mr. Lee has taken his claim to the European Court of Human Rights, whose jurisdiction will, of course, continue after Brexit because it is not an EU institution. And the question is whether the ECHR will consider his case once the Supreme Court has actually given a final and definitive ruling on the case. My own view is that it was going to decide whether Mr. Lee's application to it was admissible or not in 2020. But like many courts, as we'll see, this is a real theme of my presentation, ECHR has not actually made a decision one way or the other at the moment, and this is one we'll have to wait for next year. Two cases which Rebecca has touched on and which I looked forward to at the end of last year are the various claimants against William Morris and Barclays Bank against various claimants. Rebecca has very succinctly and very well set out what the issues were in the case. But essentially over the last 30 years, the courts have greatly expanded the activities of an employee that count for the purposes of vicarious liability. And what they've also done is extended, in what I would say vertically, the activities of people who are not employed by employers who nonetheless fix employers with vicarious liability. So it's now fairly clear cut that workers as well as employees, in most cases, their activities on behalf of their user or employer will be activities that fix the employer with vicarious liability. And then the Court of Appeal held in 2018 that a doctor who was a self-employed and was hired by Barclays Bank as a contractor would also fix Barclays Bank with liability. At more or less the same time, the Court of Appeal held that where an individual was actively operating against the interests of William Morris by stealing the personal data of its employees and publicizing it, he also was acting within his employment for the purposes of vicarious liability. I'm pleased to say that the Supreme Court decided in both of those cases that the Court of Appeal was wrong, and that where an employee was actively operating against the interests of the employer, they were unlikely, but not absolutely necessarily, going to be acting on their own and would not fix the employer with vicarious liability. The Supreme Court's judgment in Barclays Bank was rather clearer. And if you are a subcontractor, you're a separate, quite separate person to the employer, you will not fix the employer with vicarious liability. So I've marked my homework there by giving myself a tick that common sense prevailed and William Morris was successful. I've also cheated slightly because I've ticked myself there. I should really give myself a cross because I said that Barclays Bank should be successful, but I thought that it would fail, largely because of the unpleasant nature of the allegations that were made against the doctor. So moving on. Hextall against the Chief Constable of Leicestershire Police. Rebecca has already dealt with this in detail. Hextall and the other cases applied to the Supreme Court for permission to appeal, as you must, and the Supreme Court refused their application for permission to appeal. So I tick myself again there because I said they would not succeed. Then moving swiftly on to Asda Brearley, a very complicated equal pay case. Asda has appealed from the Court of Appeal that workers in retail stores who are largely women could compare themselves with workers in quite separate warehouses who were largely men because they had comparable terms and conditions which were universal, apparently, throughout England, and that were prepared and governed by a single unitary board across all the Asda stores and distribution centres. Now, Asda are going to appeal this, and I don't blame them because it's going to be a very costly decision when it gets to the end for Asda. And I have predicted that Asda will once again be unsuccessful. And we now hit a problem in my homework marking because the case was heard by the Supreme Court on the 13th and 14th of July, but we still have yet to be given judgment in the matter. Royal Mencap against Tomlinson Blake is a very important case in the care sector. Tomlinson Blake was someone who looked after those suffering from autism. She slept most of the night and was very rarely disturbed. She was given a fixed rate of pay for the night, which was considerably lower than the national minimum wage. If she was called out to assist one of her charges, she would be paid after the first hour of that assistance. She argued that she should receive the national minimum wage for the entire time that she slept. The Court of Appeal disagreed and turned her down. She has appealed and has been granted permission to appeal, and her hearing has occurred in the Supreme Court. But the case, although it was heard on the 12th and 13th of February 2020, judgment has not yet been given. And there is a problem with this case because one of the judges who listened to the case, who heard the case, has in fact died. So I'm not sure how they're going to resolve this issue. But my prediction remains that it will be successful simply because the costs are so great for the sector if they don't succeed. The case of Uber, BV and others against Aslan, this is the case that we all know about as to whether drivers for Uber are self-employed subcontractors or whether they are workers. So far, every court has found in favour of the Uber drivers. Uber have appealed to the Supreme Court, and I think that they'll be unsuccessful once again. But as of today, the case, which was heard on the 22nd and 23rd of July, no judgment has yet been given. And so we've got a bit of a mixed bag there. I think I've been broadly correct, but many of the cases that I made predictions about this time last year simply have either not been heard, or if they have been heard, no judgment has yet been given on. Thank you. Moving on. And here are my predictions for 2021. And I'm going to employ a bit of a sleight of hand or a bit of a cheat, just depending on how sympathetic you are to me. My first 4 cases for next year are in fact cases I predicted last year and which we've already been through. And the first is Lear and Ash's Baking. Second is Astor and Brill again. The third is Royal Mencap and Tomlinson Blake. And over the page, the last one is Uber and BV. I think they're all very important cases, and I very much look forward to reading the Supreme Court judgments of those cases. Moving on to something which will happen next year, Flowers and Others, the East of England Ambulance Trust. This is a very important case about working time and time off. The Court of Appeal decided that holiday pay must include regular voluntary overtime. That's in addition to compulsory overtime, which already forms part of working time for time off and for holiday pay. The case is already listed for the 22nd of June 2021, and it'll be interesting to see what happens there. And not least because the Court of Appeal based its decision on a German case in the European Court of Justice called Hein. And as from next year, the Supreme Court is going to be able to ignore European Court of Justice cases if it wishes to. My own view is the East of England Ambulance Trust will lose again, but the fact that the Supreme Court can now ignore the European Court of Justice adds an interesting twist to this case. Next, Adedeji against University Hospital Birmingham NHS Trust is a case about someone who made an application to an employment tribunal on the basis that he'd been dismissed because of racial discrimination. He presented his case 3 days late, but in fact, he presented his case on a Monday when he should have presented it on a Friday. So he really was very close to the deadline. Crucially, I think he was legally advised as to his case and the time limits that applied to it. But nonetheless, in circumstances where the employment tribunal could have given him a just and equitable extension, I think they were rather mean not to. And I think the EAT was rather mean to uphold the employment tribunal's judgment. And because this is the season of goodwill, I think that Mr. Adedeji will be successful in the Court of Appeal. So that's my prediction for that case. Moving on. This is an interesting one. Addison Lee Limited against Lang, Court of Appeal. It's an interesting example of how lower courts wait for decisions in higher courts, because this is effectively the same type of case as the Uber against Aslam case, which, as we've seen a few minutes ago, the Court of Appeal has heard but hasn't yet given judgment about. And what the Court of Appeal has done, if I could put it this way, is parked this case in order to discover what the Supreme Court's judgment is in Uber and Aslam. And when that judgment is given, then the Court of Appeal will give their judgment in this case. And I have little doubt that it will follow the judgment in the Court of Appeal, as I predict that Mr. Aslam will succeed in the Supreme Court. I also think that Mr. Lang will succeed in the Court of Appeal. The next one is a community-based healthcare limited against Narayan. And this is it was an EAT case which held that a GP who was registered with community-based healthcare was nonetheless a worker, even though they supplied their services through a limited company. And again, this is an interesting example of how Supreme Court cases affect cases lower down, because I think the Court of Appeal is going to find it very difficult to find in favour of Narayan, when one of the crucial reasons for its decision in the Barclays Bank case was that the doctor there was a subcontractor and therefore could not make Barclays Bank vicariously liable. I think here, although the question of law is different, I think in order to be consistent with Barclays Bank case, in the Narayan case, the Court of Appeal is going to have to hold that Narayan, working through a limited company, cannot fix Community Healthcare Limited with liability, or cannot be a worker. They must be a subcontractor. Next, Conisbee against Crosley Farms Limited. Here, the ET, the Employment Tribunal, decided that vegetarianism is not a belief qualifying for protection under the Equality Act, and the claimant appealed. I have some sympathy with the claimant here, because it was decided by the Employment Tribunal that there were various reasons why people became vegetarian, and therefore, in part, that was the reason why it was not a coherent set of beliefs as a religion would be. But it seems to me that many people adhere to a particular religion for many different reasons. The motive isn't as important as the practice itself. That's my own view about this thread of Employment Tribunal judgments in this area. And so I think the Appeal Tribunal will find in favour of the claimant, Mr. Conisbee. However, having said that, I say the claimant will lose. In fact, my prediction is the claimant will win. But I believe that the claimant may well have withdrawn this case because I think it's been settled. I've heard a rumour that it's been settled. So it may be that when I come back to this in 2021, I'll say it was a bit of a damp squib because it was never heard by the EAT at all. And then finally, Smith against Pimlico Plumbers in the EAT. This is a case that has been going on for many years. You may recall it because Pimlico Plumbers were found by the Supreme Court to have, that Mr. Smith was their worker rather than a subcontractor, as Pimlico Plumbers claimed. But Mr. Smith, having been successful in showing that he was a worker rather than a subcontractor, unfortunately discovered that he hadn't made any claims about not only arrears of holiday pay, but sick pay and other forms of pay. His claims for payment are actually quite complicated, but unfortunately he didn't plead them in his original Employment Tribunal application form. So Pimlico Plumbers have now claimed that since none of these claims were in his original claim was merely about worker status, he isn't now entitled to those arrears because it's not fair, it's not just that he should amend his employment, his ET1 in order to make these claims now. The Employment Tribunal agreed with Pimlico Plumbers and struck his claims out. So although he was very successful in the Supreme Court, he's found himself to be without a remedy. Now, because it's Christmas time, I'm going to say that the EAT will find in his favour when they come to hear the case at some point in 2021. And so those are my predictions for next year. I'm sorry about cheating a little because I've moved on. I have repeated some of my predictions from last year, but I hope that was interesting and enlightening in some ways, and in some ways good fun as well. You're going to have much more fun now because you're going on to a quiz organised by Will. But I'm going to hand you back to Rebecca. Thank you for your time.
Thank you for joining us this afternoon. We will be sending out our 2021 webinar invites in a couple of weeks, but the first one will take place on the 14th of January. So do watch out for the invite in your inbox. All that remains for me to say is thank you very much from all of the team at DMH for your support during 2020. We've loved working with you. We hope we've been able to give you some guidance and support and get you through a really difficult year and come out the other side. We'll see you all in 2021 and have a very happy and healthy Christmas from us all. Thank you. Bye-bye.